Well, the Arizona Senate has passed a bill to make it easier to own a gun silencer, more accurately called a suppressor.
We can't pick and choose, and we have to follow the laws, but people don't understand.
We were reminded how dangerous silencers can be a few weeks ago.
We don't want to have those silencers end up in the wrong people's hands. One way to definitely do that is not sell them here in Illinois.
State lawmakers are considering several changes to gun laws, including making these much easier to get.
Suppressor freedom unleashed. The ongoing legal battle surrounding the suppressor freedom lawsuit has recently witnessed significant developments, particularly in two pivotal cases, Morse versus Raoul and Anderson versus Raoul. Both lawsuits have been filed in a federal district court in Illinois, with the primary objective of challenging the state's ban on the purchase and possession of suppressors. This legal saga holds national importance, as 42 states currently permit the ownership of suppressors, yet 9 jurisdictions within the U.S., including Illinois and California, impose bans on these NFA items. If successful, these Illinois lawsuits could set a groundbreaking precedent, establishing that a state's outright ban on NFA items, such as suppressors, is unconstitutional. The crux of the matter lies in the state of Illinois' vigorous attempt to have the case summarily dismissed. Their argument pivots on the assertion that suppressors do not qualify as arms and therefore fall outside the purview of Second Amendment protection. This pivotal legal maneuver is aimed at securing a judgment on the pleadings, effectively terminating the case before it progresses further. The state contends that the plaintiffs lack a valid position to demonstrate that suppressors constitute arms deserving of constitutional protection. However, a recent judicial decision in California is poised to influence the trajectory of the suppressor freedom lawsuit in Illinois significantly. The plaintiffs have submitted Judge Bonus's decisions in 2 noteworthy California cases, Miller v. Bonta and Duncan v. Bonta, as part of their legal strategy. In these California cases, Judge Bonus delivered rulings that could potentially reshape the landscape of the Illinois suppressor lawsuit.
Well, the Arizona Senate has passed a bill to make it easier to own a gun silencer, more accurately called a suppressor.
Gun enthusiasts hope lawmakers will pull the trigger and lift the ban on silencers.
As suppressors, illegal nationwide, just as they are in New Jersey.
State lawmakers are considering several changes to gun laws, including making these much easier to get.
The decisions in Miller v. Bonta and Duncan v. Bonta, which address the legality of certain arms restrictions, affirm the constitutional rights of individuals to possess firearms protected by the Second Amendment. These decisions stand as recent victories for proponents of individual arm rights, influencing the ongoing legal discourse surrounding the Illinois suppressor lawsuit. By leveraging these California decisions, the plaintiffs in the suppressor freedom lawsuit are strategically bolstering their argument that suppressors should be recognized as constitutionally protected arms. The legal landscape is evolving, and these recent victories in California contribute to the broader narrative challenging restrictions on arms and accessories. As the legal battle unfolds, the suppressor freedom lawsuit remains a focal point for those advocating for expanded Second Amendment rights. The outcome of these cases in Illinois may have far-reaching implications, potentially paving the way for challenges to similar bans in other jurisdictions. The interplay between state regulations, constitutional rights, and recent legal precedents underscores the complexity and significance of this legal battle. As stakeholders await further developments, the suppressor freedom lawsuit continues to shape the contours of the ongoing debate surrounding arm rights and regulations in the United States. Second Amendment showdown. The legal landscape surrounding the suppressor freedom lawsuit in Illinois has taken a significant turn, with the Anderson versus Raoul case presenting a robust argument against the state's attempt to dismiss the lawsuit. The heart of the matter lies in the assertion that suppressors, the subject of contention in these cases, are bearable arms in common use for lawful purposes, and thus fall within the ambit of Second Amendment protection. In the Anderson lawsuit, the plaintiff contends that suppressors are widely utilized by law-abiding citizens for legitimate purposes, and are therefore neither dangerous nor unusual. This argument is rooted in the notion that modern arms, beyond the muskets often referenced in anti-arm rhetoric, enjoy protection under the Second Amendment. The plaintiff draws support from the Supreme Court's pronouncement in the case of Bruin, where it was reaffirmed that the Second Amendment's historical application extends to contemporary circumstances and encompasses all instruments constituting bearable arms. Crucially, the plaintiff in Anderson rejects the argument put forth by the state of Illinois that suppressors are not protected by the Second Amendment due to their absence during the 18th century founding era. This contention is deemed irrelevant in light of precedent-setting decisions such as Heller and Bruin, where the Supreme Court explicitly rejected the notion that the Second Amendment only protects arms in existence during the founding era. Instead, the court emphasized that the Second Amendment encompasses modern forms of bearable arms, extending its protection to instruments not present at the time of the nation's founding.
We can't pick and choose, and we have to follow the laws, but people don't understand.
Our neighbors to the east and west allow silencers.
The State House still has to vote on the bill. 9 on your side's Craig Smith looked into how much difference a suppressor makes.
How much louder is it without the silencer?
It's about 6 times louder without the silencer.
The outcome of this legal battle holds implications not only for the suppressor freedom lawsuit in Illinois, but also for the broader discourse surrounding arm rights and regulations in the U.S. If the plaintiff prevails, it could set a precedent affirming the constitutionality of suppressor ownership, challenging restrictive state-level bans. Conversely, a ruling in favor of the state could reinforce the authority of states to regulate and prohibit specific firearm accessories, potentially impacting similar challenges nationwide. Suppressor Rights Challenge. The legal battleground surrounding suppressor rights in Illinois has intensified with the state's strategic move to file a motion for judgment on the pleadings. This procedural maneuver holds immense significance as it aims to determine the viability of the plaintiff's claims under the Second Amendment before proceeding to a full trial. A successful motion could result in the outright dismissal of the case, preventing future challenges on similar grounds. A motion for judgment on the pleadings is a pretrial motion made under the Federal Rules of Civil Procedure, specifically Rule 12c. This type of motion is designed to assess the merits of the case, based solely on the contents of the parties' pleadings and any attached documents. Unlike a trial, where extensive evidence is presented, this motion confines the court's review to the information provided in the pleadings and associated documents. If the party filing the motion prevails, the court may dismiss the claims, potentially foreclosing the possibility of similar lawsuits being brought in the future. The state of Illinois, in its motion, puts forth a robust argument challenging the plaintiff's Second Amendment claims. The core of the state's position lies in the assertion that silencers, or suppressors, do not qualify as arms within the meaning of the constitutional text protected by the Second Amendment. The state contends that while the Second Amendment safeguards the right of the people to keep and bear arms, silencers, in their view, do not fall into the category of arms.
We were reminded how dangerous silencers can be a few weeks ago.
Some people call these a silencer, but how much silence are we really talking about?
Fitted with a suppressor to kill 12 Americans in Virginia Beach.
For that reason, these things aren't oftentimes falling into the wrong hands.
It also bans large magazines and rapid-fire attachments.
According to Illinois, the functional purpose of silencers, namely noise reduction, sets them apart from the category of arms protected by the Second Amendment. This legal contention raises fundamental questions about the scope of Second Amendment protections and the classification of accessories like suppressors. The state's position hinges on the belief that the constitutional text, which safeguarded the right to bear arms, does not encompass items that do not function as weapons. It challenges the notion that suppressors, as accessories, deserve the same constitutional protection as arms. The outcome of this motion will significantly influence the trajectory of the suppressor lawsuit in Illinois and potentially set precedent for similar cases in other jurisdictions. The central question remains whether the court will accept the state's argument that suppressors are not arms within the purview of the Second Amendment, or whether it will affirm the broader interpretation of the right to bear arms, encompassing accessories integral to the use of arms. Suppressor lawsuit unraveled. The suppressor lawsuit in Illinois has entered a critical phase as the state seeks to discard existing laws, including the National Firearms Act, which designates suppressors as actual arms and weapons in their own right. This move challenges a federal law passed by Congress that explicitly categorizes suppressors as arms. It raises questions about the state's attempt to override federal legislation and redefine the legal status of suppressors. The NFA, enacted in 1934, imposes stringent regulations on certain arms and accessories, including suppressors. Despite the federal classification of suppressors as arms, the state of Illinois is pursuing a path of disregarding these federal regulations. The state's argument centers on the notion that the Second Amendment does not necessarily align with the federal classification of suppressors as arms. This raises a constitutional and legal dilemma, as it questions the interplay between federal and state laws in defining the status of specific firearm accessories.
We don't want to have those silencers end up in the wrong people's hands. One way to definitely do that is not sell them here in Illinois.
Mufflers on our vehicles is because they're incredibly loud. That output is incredibly loud. The muffler helps dampen that noise. The suppressor is the same way.
Makers of the silencers are the ones pushing state lawmakers to lift the ban, and they have found at least one supporter.
That as the sheriff, we're the keeper of the jails. We do have a say who can come in and out of our jails.
A significant setback for the state of Illinois comes in the form of a reference to the Miller versus Bonta case in California. The California case challenges a state-level assault weapon ban and has relevance to the arguments presented in the suppressor lawsuit in Illinois. The Miller versus Bonta case has become a touchstone for advocates of Second Amendment rights, as it challenges state regulations that restrict the types of arms and accessories individuals can possess. The outcome of the California case may have implications for the suppressor lawsuit in Illinois, shaping the legal landscape surrounding arm rights. In supposition, the suppressor lawsuit in Illinois raises complex questions about the relationship between federal and state laws, the classification of firearm accessories, and the interpretation of the Second Amendment. The state's attempt to discard federal regulations and narrow the scope of the Second Amendment faces challenges, including the acknowledgement of a broader definition of arms and the reference to precedent-setting cases like Miller versus Bonta. As legal proceedings unfold, the case will continue to be a focal point in the ongoing debate over arm rights and regulations in the United States. California precedent shapes. The legal landscape surrounding the suppressor lawsuit in Illinois has been further influenced by recent rulings in two pivotal cases in California, Duncan versus Bonta and Miller versus Bonta. These cases, specifically addressing the California ban on certain rifles and mags, have become significant touchstones in the broader Second Amendment debate and are now playing a crucial role in the Illinois suppressor lawsuit. In both Duncan versus Bonta and Miller versus Bonta, Judge Benitez delivered rulings declaring California's restrictions on rifles and mags as unconstitutional. The essence of these cases echoes the arguments put forth in the Illinois suppressor lawsuit, as they involve challenges to state-level restrictions on firearm accessories and configurations. The rulings in California have far-reaching implications and have set a precedent that is now being invoked in the ongoing legal battle over suppressor rights in Illinois. In Miller versus Bonta, the state of California attempted to argue that certain rifle accessories and configurations subject to restrictions did not violate the Second Amendment. The state contended that these features were not arms themselves, and therefore the restrictions imposed on them did not infringe on Second Amendment protections. However, Judge Benitez rejected this argument, asserting that these configurations and features constituted arms and were therefore shielded by Second Amendment protections.
Why do we have guns? Why do we have the Second Amendment?
The Supreme Court has refused to change laws that limit access to gun silencers.
Joseph Story, in his commentaries on the Constitution in 1833, quote, "the right of the citizens to keep and bear arms."
This ruling challenged the notion that restrictions on certain firearm accessories were outside the scope of constitutional protection. Similarly, in Duncan versus Bonta, the state of California contended that mags, as standalone items, were not arms protected by the Second Amendment. The state argued that individuals did not have an inherent right to access any type of mag they desired. Judge Benitez again rejected this argument, affirming that mags, in their own right, were arms protected by the Second Amendment. This ruling countered the notion that restrictions on the type and capacity of mags could be justified outside the constitutional framework. Both Miller and Duncan cases are currently under review in the Ninth Circuit, a jurisdiction known for its impact on Second Amendment cases. Despite the complexities and challenges within the Ninth Circuit, these cases serve as critical benchmarks, shaping the legal discourse around firearm rights. Importantly, the plaintiffs in the Illinois suppressor lawsuit have strategically submitted these cases to the judge as supplemental authorities, seeking to bolster their argument against Illinois' motion for judgment on the pleadings. The judge in the Illinois suppressor case has accepted these supplemental authorities, indicating that the rulings in Miller and Duncan are being considered as relevant legal precedents in the context of the suppressor lawsuit. This introduces a compelling layer to the Illinois case, as it draws parallels between the arguments presented in California and those underpinning the challenge to suppressor bans in Illinois. The broader implication of these developments lies in the interconnected nature of Second Amendment cases across different jurisdictions. Legal victories or challenges in one state can serve as persuasive authorities in cases elsewhere, creating a ripple effect in the ongoing struggle to define the boundaries of constitutional firearm rights. 2A victories resonate. The interconnected nature of Second Amendment cases across different jurisdictions highlights the significance of recent victories, particularly in California, where challenges to mag and rifle bans have set influential precedents. The impact of these victories extends beyond the state's borders, with the rulings being strategically leveraged in support of other 2A cases, including the ongoing suppressor lawsuit in Illinois. The recent wins in California, specifically in Duncan v. Bonta and Miller v. Bonta, where Judge Benitez ruled against the mag and rifle bans, are now playing a crucial role in supporting the Illinois suppressor case. The legal strategy involves using these victories as persuasive authorities, citing them in support documents to strengthen the argument against Illinois' motion for judgment on the pleadings. The key concept at play is the use of legal precedent as a tool for advancing 2A rights. A favorable outcome in one jurisdiction becomes a precedent that can be referenced and applied in support of similar arguments in other cases, creating a ripple effect in the fight for arm rights. In the context of the Illinois suppressor case, the victories in California are not only a source of inspiration, but tangible legal support that can be submitted to the court as supplemental authority. The strategic use of legal precedent is a powerful tactic in shaping the trajectory of 2A litigation. If the Illinois suppressor case secures a favorable decision, it has the potential to be used as supplemental authority in challenging suppressor bans in other jurisdictions.
Since it offers a strong moral check against the usurpation and arbitrary power of rulers.
The ruling leaves in place a federal law requiring the registration of silencers.
We have a Second Amendment because we understand in this country that there are some things, inalienable rights.
This domino effect allows legal victories to reverberate across the nation, influencing the interpretation and application of the Second Amendment. While the outcome of the Illinois suppressor case is yet to be determined, the fact that the judge is considering recent victories in California as support for potentially rejecting the state's motion for judgment on the pleadings is a positive sign. It suggests a recognition of the broader legal landscape and an acknowledgement that legal victories in one jurisdiction can have persuasive authority in cases elsewhere. The Illinois suppressor case, if successful, could become a catalyst for challenging suppressor bans in other states. The legal arguments and precedents established in one jurisdiction can be used strategically to bolster challenges in areas with similar restrictions on arm accessories. This interconnected approach strengthens the collective effort to protect and expand 2A rights nationwide. Role of advocacy groups. Advocacy groups play a pivotal role in shaping public discourse, influencing policy decisions, and advocating for specific causes or rights. In the context of Second Amendment rights and arm-related issues such as the regulation of suppressors, advocacy groups have a significant impact on legislative, judicial, and societal perspectives. These groups serve as vocal proponents for the protection and expansion of Second Amendment rights related to arm ownership, including the rights associated with suppressors. They work to educate the public and lawmakers about the historical, legal, and practical aspects of suppressor use. Through various campaigns, lobbying efforts, and legal initiatives, these groups aim to ensure that lawful arm owners have access to firearm accessories like suppressors while promoting responsible usage. Advocacy groups often engage in educational outreach programs, providing factual information about suppressors to dispel myths and misconceptions. They emphasize the safety benefits of suppressors in reducing noise pollution, preventing hearing damage, and enhancing shooting experiences. These groups also highlight the lawful and legitimate uses of suppressors in hunting, sport shooting, and personal defense.
Tyrants disarm the people they intend to oppress. Those are the facts.
They're banned in 8 states and D.C. Other states ban them unless they are registered with the Bureau of Alcohol, Tobacco.
In Cambodia, the Khmer Rouge were able to take advantage of the fact that limited gun ownership.
Moreover, these organizations actively participate in legal battles, funding lawsuits and providing legal expertise to challenge restrictive laws or regulations on suppressors. They work to advance cases through the judicial system, leveraging legal precedents, constitutional arguments, and expert testimony to support the rights of individuals seeking access to suppressors. In influencing policy decisions, advocacy groups engage with lawmakers, providing input and advocating for legislation that aligns with their goals. They strive to shape regulations and laws that balance public safety concerns with the preservation of Second Amendment rights, including the rights related to suppressor ownership and usage. Additionally, these groups serve as a platform for individuals sharing similar beliefs and concerns regarding firearms, providing a sense of community and unity in advocating for their rights. Through membership, grassroots activism, and fundraising efforts, they amplify their voices and mobilize support for their cause. Ultimately, the role of advocacy groups in the realm of suppressor rights and Second Amendment advocacy is multifaceted. They act as catalysts for change, driving conversations, influencing policy decisions, and safeguarding the rights of individuals to responsibly own and use firearms, including suppressors, within the framework of the law. Public reaction and debate. The Supreme Court's decision to prevent suppressor bans has triggered a diverse range of public reactions and ignited a passionate debate across the nation. As with any significant legal development, public sentiment on this issue is varied, reflecting a spectrum of perspectives on Second Amendment rights, arm regulations, and the role of government in shaping arm-related policies. Supporters of the decision hail it as a victory for individual freedoms and the protection of the Second Amendment. Advocates argue that the ruling upholds the right of law-abiding citizens to access and use suppressors without facing arbitrary bans. They emphasize the practical benefits of suppressors, such as noise reduction and hearing protection, particularly in the context of recreational shooting and self-defense scenarios. These individuals often view the decision as a step towards preserving the original intent of the Second Amendment and resisting what they perceive as undue governmental restrictions. Conversely, critics of the decision express concerns about potential implications for public safety. Some argue that allowing broader access to suppressors may hinder law enforcement efforts by making it harder to detect and respond to arm fire. They contend that the noise created by arm fire serves as an important safety feature, alerting the public and law enforcement to potentially dangerous situations.
After that shooting, President Trump suggested he would look into restrictions on gun silencers.
Reasonable to conclude that gun confiscations facilitated by laws requiring the registration and licensing of firearms.
A silencer was used in the recent Virginia Beach massacre that left 12 people dead.
This perspective raises questions about the delicate balance between individual rights and public safety, fostering a contentious debate on the societal impact of suppressor use. The media plays a crucial role in shaping public perceptions and contributing to the ongoing discourse. News outlets and social media platforms amplify the voices of both supporters and critics, providing a platform for individuals to express their opinions and engage in discussions. The framing of news stories and the selection of narratives can influence how the public interprets and responds to the Supreme Court's decision. This development has also sparked conversations about the broader landscape of arm control in the U.S. It prompts a re-examination of existing arm regulations, fueling debates on whether certain restrictions are necessary for public safety or whether they infringe upon constitutionally protected rights. In the midst of this public reaction and debate, it is important to consider the potential ripple effects on future legislative and legal challenges related to arm regulations. The Supreme Court's decision may inspire new advocacy initiatives, legal challenges, or legislative efforts on both sides of the arm control debate. That's all for this video, folks. See you next time.